prosecutors on the case, different eyes looking at the case, and wanting to make sure that we have provided not just the witness list, but we acted in good faith to provide as much information as we could. And Your Honor, we did not hold anything back with any of these witnesses' names in them. The discovery containing the names were provided, Your Honor, and to the extent that we have gone as far as we have, they have now had the witness list for 2 months at least, Your Honor. Opening statements were far away from 10 days at the time that we provided the most recent witness list. That witness list is just the result of not bad faith, Judge.
But to their point, okay, you got, cases indicted in May. It was re-indicted when, in August? Or was it later than that? I'm sorry. I don't know when it was re-indicted.
It was re-indicted. That is correct. I don't have the exact re-indictment date, but it in fact was re-indicted. We'll get that for the court.
Okay, so it's re-indicted. But here's the thing. Then we started our commenced trial. December we had motions. December of 2022 we had motions. And we actually started, I want to say, the 4th of January of 2023 with actually joining issue and going ahead and selecting our jury, being in the process to select our jury. So, to the defendant's point, if the witness is supposed to be served, in 10 days or before arraignment, we've been kind of working consistently since January of this year, and it ain't like, I'm sorry, I'm using the vernacular. It's not like you got 10 witnesses or 20 witnesses or maybe even
That's correct,
40 or 50 witnesses. And you've got several hundred witnesses that arguably Mr. Steele and all the other people that are in this case need to go ahead and vet, because any defense attorney worth their salt is going to talk to everybody, or going to at least attempt to reach everybody who's on that witness list. So if the target keeps moving, what do you say about that? I mean, because it's grown from less than 50 to over 700.
I'm saying that shows our good faith, the fact that we are trying to provide that list, the fact that we are trying to provide them, pull out of the discovery and provide to them an actual list with all of the information about the witnesses that we can gather, along with the counts and acts with which they are associated. That is a sign of good faith, not bad faith. And we have not argued on a technicality. All of the motions to suppress file long after indictment that we have now addressed on a substantive basis that Defendant Williams has filed. That's further good faith on the part of the state, Your Honor. The defendant now is trying, I guess, to assert that, somehow his designs on keeping out information that he feels isn't good for himself is amounting to bad faith on the part of the state, when he cannot point to any action but good faith action on the part of the state. Us providing those witnesses, more signs of our good faith, Your Honor. There is no bad faith, and it is necessary, Your Honor, to find bad faith, ill will, intended bad faith, and prejudice in order for the court, for courts to sanction the extreme remedy of excluding evidence or excluding witnesses. There are a number of ways that if the defendant wants more time to look over his Instagram pages that we provided notice of back in August of 2022, then he can have that time or request that time. An administrative day or recess for him to do that does not take away his rights under his speedy trial demand. But to say that somehow the state has acted in bad faith when there's been nothing but a showing of good faith is simply misrepresenting reality, Your Honor.
I have some concerns. I really do, Ms. Lowe, in terms of the number of witnesses and that have continued to grow. So my concern is that they need to be able to interview and to talk to these witnesses. So
And, Your Honor, that's why we've given them the phone numbers, the addresses. We, of course, cannot force anyone to talk with anyone. And to the extent that the smaller portion of the witness list is lay witnesses, which one might arguably have a problem finding or dealing with, the vast majority of them, the larger chunk of them, are professional witnesses.
Okay, but you told me that you're going to need all of these 737 in terms of witnesses to put on your case, and I'm not you, but I'm you know, kind of asking you again, what is the more realistic universe of witnesses that you think you're going to call in this case? Is it 300, 400? I mean, I'm not holding you to that, but I mean, we got 6 defendants left, so it's kind of like, I know you got to put on your case, but...
And I can assure the court that we are culling those witnesses. We are going through and we are paring down that list. And we can probably have a list of a pared down, if you will, sort of rendition of it for the court on the 20th, if the court permits us to present that to the court. And I understand the court's concerns as well, because the court wants to present as smooth and as fair a trial as possible for all parties.
I do, but you know, the other thing is, if I'm, you know, I mean, these are real numbers, and you know, anybody who's tried a case before understands the legwork that goes into being prepared. And you know, even if I don't believe that you all, you know, were doing this in bad faith or you had the intent to do it, it doesn't still sit well wrong with me from a constitutional standpoint in terms of just being able to be prepared. Mr. Steele's other constitutional issues of, yeah, he's got to be prepared, he's got to do his job, and doing your job means you got to go ahead and make sure I've interviewed all the witnesses that potentially are going to be called in this case, or to account for them.
Your Honor, we don't disagree with that, but we're just asking that the court not invoke the extreme remedy of excluding them. We're asking that the court fashion a remedy such as allowing additional time for the interviewing of witnesses. We have asked Mr. Steele and the other defendants if they would provide to the state people that they are not able to reach. We have not received anything from anyone since we have given the last list of witnesses from anyone saying that they have not been able to reach someone on the list.
Here's what I'm going to do.